Good afternoon, everyone. Good morning to some of you, maybe on the West Coast. My name is Kylie Hall, and I am the Operations Director at the North Dakota State University Center for Immunization Research and Education. Today, it is absolutely my pleasure to introduce Dr. Dorit Reiss. She will be presenting our webinar today titled The National Vaccine Injury Compensation Program, Continuity and Change. So Dr. Reiss is a professor of law and the James Edgar Hervey Chair in Litigation at the UC Law San Francisco. She specializes in vaccine law and policy, including exemption laws and tort liability related to non-vaccination. She has published in law reviews, peer-reviewed journals, and blogs on legal and policy issues related to vaccines, and even co-authored a book on vaccine law and policy with Professor Y. Tony Yang. Dr. Rice, you can begin.
Thank you for having me, and I'm very excited to hear feedback and questions about this. I have one disclosure, which is my family owns stock in GSK. As mentioned here, it's been mitigated. What I hope you learn today is I hope you learn why no-fault systems are used for compensating vaccine harm. I hope you understand the creation and structure of the vaccine injury compensation program, and I hope you'll be able to assess potential reforms of the program. The way I'm going to go through it is I'm going to give you a short introduction to vaccine risk and no-fault systems. Then I'm going to spend quite a bit of time talking about the vaccine injury compensation program and a much shorter time talking about the countermeasure injury compensation program, which is the one we use to compensate COVID-19 vaccine harms. And then I'm going to talk about reforms that are in the works and what they might mean. And then I hope to leave time for questions. So let's start. The starting point is that if anyone tells you that something that really works on the body doesn't have any side effects, you shouldn't believe them. As anything else, vaccine have side effects. This is an example of the first vaccine, the smallpox vaccine side effects. And as you can see, they're not exactly trivial. About 1,000 in a million would have a serious allergic reaction. Um, some can have life-threatening reaction, and some died. We have very low tolerance to risk from vaccines correctly because vaccines are given to healthy people. So modern vaccines would have substantially less side effects than this. Uh, I'm using a comparison from the Australia National Immunization Program because we don't provide the same on our government website. But if you look at it, you'll see that although vaccines have side effects, for example, a severe allergic reaction is a risk with any vaccine, they're substantially smaller than the risk of the disease. But they do happen. And the question is, what do we do when those happen? One option is to send people to the regular courts. That was the case before the creation of the Vaccine Injury Compensation Program. The problem is that the process in civil courts is hard and that vaccine profits for routine vaccines are low enough that even unsuccessful litigation has in the past driven manufacturers out of the market. To give you one example, this is a case in which Mr. Tenuto sued Lederly Lab after he was paralyzed by an oral polio vaccine. Mr. Tenuto's young daughter, as an infant, got her oral polio vaccine. Unlike the currently used injected polio vaccine, the oral polio vaccine in 1 out of 2 to 3 is a live virus vaccine, and in 1 out of 2 to 3 million doses, the virus reverts to its wild form and can cause polio. Mr. Tenuto's daughter did not get polio because she already had one dose of the vaccine at 2 months. But when Mr. Tenuto likely changed her diapers, he got polio and he was not immune. So he ended up paralyzed. He sued Lederly Lab, and it should have been an easy product liability case because it's clear that the oral polio vaccine can cause this. Causation is a big problem for many vaccine cases. And he made a good claim of lack of warning. But although he was paralyzed in 1974, it took until 2010 for him to be compensated. He won his case, but it took a long time. Product liability cases are hard because it's often hard to show a product defect. Um, to show a design defect, you need to show that the risks of the vaccine outweigh its benefit or that there's a safer alternative version. For many vaccines, that just wouldn't be true. On top of that, you need to show that the vaccine caused the harm and you would need to show your damages. Another alternative to go when you go to the courts is to sue for medical malpractice, sue the doctor vaccinating. But that's also hard because most of the time, vaccinating a child is not medical malpractice. So litigation through the civil courts is hard in these issues. What's the advantage of no-fault system? No-fault system means that you don't have to show fault. You don't have to show negligence. You don't have to show product defect or fraud or anything else. You still, because you're being compensated for a vaccine harm, have to show that the vaccine caused your harm and have to show what your damages are. But it's a big break for people going through them. And I'll go into our vaccine injury compensation program in a little while. I do want to mention that we're not the only country that has no fault compensation for vaccine. About 25, I'm giving you an article so that you can look it up later. About 25 countries use no compensation systems to compensate for vaccines. Other countries like Canada and still Australia use the regular courts. And from my experience, in countries that use the regular courts, cases are rare and wins are even more rare. I'm saying that to emphasize that going through the usual court system isn't a benefit for people with real vaccine injuries in a lot of times. They have to show more, not less. There are some benefits. For example, in the United States, you'd have more discovery available in a civil case, but there are a lot of other things that are not benefits. Why no compensation? Why no fault? What's the justification? Why do 25 countries use this approach? And it started in Germany in the 1950s. There are several good reasons to use a no-fault system for vaccines. First, for people who have real vaccine harm, it's easier. They are more likely to be compensated if they don't need to show fault. From the point of view of society, it's actually fair. So vaccines do two things, as you probably know. They protect you, but they also protect others by creating community immunity. Because vaccines have a public benefit, it's unfair that the 1 in a million rare harm from cases from vaccine would have to bear the cost. It's fair for the public to compensate them. If they have to show negligence or product liability, they won't be compensated even if the vaccines caused their harm, if there wasn't negligence or product defect. A no-fault system allows them to be compensated and spread the costs on society rather than just on the victim. If we can point out to people that they have an easier compensation system, it should also increase vaccine confidence. People will be more likely to vaccinate if they realize that if something goes wrong, they will be compensated. And to give you a full picture, there are some real concerns about no-fault system. Because no-fault system almost always come with limited liability, it's a compromise. We give an easier way to compensate, but we limit the liability of the companies. The government pays. There are concerns that the companies aren't held accountable enough. There are also in the United States concerns because discovery in the no-fault systems is more limited than in the civil courts. In the vaccine injury compensation program, discovery is in the discretion of the special master, and it often doesn't happen because you don't need it for those kind of cases. You need discovery when you need to show fault most of the time. And that is a concern for people who think discovery is a really important tool. So the next slide will ask you a question. What is an important difference between regular civil litigation and no-fault system? I'll be quiet for a moment to give you a chance to answer. Please answer. You can.
Dr. Reiss, I do see a few people responding in the webinar chat. So I have seen a couple of individuals who chose A, and a majority have chosen the letter C.
Good. So those answers are correct. The ones that answered C are correct. A is a common belief, but it's not actually correct. You still need to show that a vaccine caused your harm, even in a no-fault system. The real difference is that in a no-fault system, you don't have to show a product defect, negligence, fraud, or other conduct. So the correct answer here would be C. You don't have to show a product defect, negligence, fraud, or other conduct. Okay, let's talk here. Now I can close it. Okay, so let's talk about the United States Vaccine Injury Compensation Program. So with a bit of background here, um, debate about adding a no-fault compensation program started long before VICP, at least as late as the 1970s. There were already discussion on whether we should move to no-fault for vaccines. And I also want to tell people that if you're looking for a more in-depth look at the history and some of the functioning, I recommend Anna Kirkland's book, Vaccine Court. Anna Kirkland is a scholar with Michigan University who wrote a book about this. So in the 1980s, there were concerns that the diphtheria pertussis tetanus vaccine could cause brain damage. And the concerns led to law uptake and to lawsuits. At the time, we were also seeing lawsuits about polio vaccines, but they were a lot less than the lawsuits around the DPT. The result of that, so most of those lawsuits lost, but a few of them won, and some of them won large jury damages. Manufacturers reacted by leaving the market. Um, in part, it was because it was not worth their while to litigate. The profit wasn't large enough. The United States went from 18 manufacturers manufacturing DPT to three, with two talking about leaving the market as well. Congress was concerned that we might not have the ability to protect children from diphtheria, pertussis, and tetanus. At the same time, the people bringing those claims, the plaintiffs, were not happy because compensation was really difficult. Most of these cases lost, and a lot of them lost because they couldn't show a vaccine defect or a negligence. The result was a compromise that nobody was completely happy with, but addressed the issue. That was the National Childhood Vaccine Injury Act of 1986. That's generally referred to as the Vaccine Act. So if you hear me talk about the Vaccine Act, that's what I'm referring to. It did a few things, but the one we're focusing on right now is the creation of the Vaccine Injury Compensation Program. And officially, in the materials of the Act, it had two goals. One of them was to protect the vaccine supply, to make sure that manufacturers are less likely to leave the market. And it did so mainly, and I'll go back to it a little later, it did so mainly by creating liability protection, which means that people had to go through the program first before they could take manufacturers to court. They could still take manufacturers to court, but they had to go through the program first. The second thing is aimed at the people claiming vaccine injury, and that's to give them an exclusive, swift, flexible, and less adversarial alternative. This is taken from the language around the purposes of the act, so that's why it's a little cumbersome. But at least part of the goal was to give petitioners a better option than regular going to courts. At the beginning, the program covered 6 vaccines that were all for children. At the beginning, the program really was about childhood vaccine. That has changed. Today, these are the vaccines covered by the Act. We have the DTP, or in all its variety, diphtheria, tetanus, and pertussis, HIB, hepatitis A and B, HPV, flu, measles, mumps, meningococcal, pertussis, and pneumococcal. If you're looking at this, you probably realize, even at a glance, that while many of these vaccines are childhood vaccines, some less so. And I want to point out influenza, and I'll get back to it in a moment. I'm looking at my notes to make sure I don't skip any of the points I wanted to add. How does the, here, I went a little too fast. Hop. Some of the things about the program has changed in recent times, and the changes are extremely important. Probably the most definitive change on the way the program operates today was adding influenza vaccine to the table of injuries. The table of injuries lists all the vaccines covered by the program, and that was important for a number of reasons. First, if childhood vaccine are given to new babies and then again to children, and we have a 4 million birth cohort every year, influenza vaccine are supposed to be given to everybody. So that raises the number of people vaccinated dramatically. So if you have, instead of 4 million babies, 150 million vaccinated a year, you're going to see more claims. Today, most of the claims in the program are from adults, and the majority of them are from influenza vaccines. So what started as a program aimed at compensating children is now very much a program that compensates adults. one of the things we're seeing is a change in which a very large number of the current claims are focused on shoulder injury related to vaccine administration. In other words, they're not about the content of the vaccine. So instead of childhood claims focus on the content of the vaccine as potentially creating harm for children, today's program a lot of time deals with adult cases of people claiming harm from influenza vaccine, and a lot of these are about vaccine administration rather than content. In addition, another thing that influenced the program is the dismissal of the omnibus autism proceeding in 2009-2010. In the early 2000s, claims that vaccines cause autism reached a peak, and a lot of parents filed claims with the program claiming that vaccines cause their child autism. Those was consolidated in one big case that used 60 test cases to assess if vaccines cause autism at all. And in 2009, 2010, the first 6 test cases were dismissed in very lengthy decisions. And after that, about 5,000 cases from the program ended. Some of them, the parents withdrew their case. Some of them, the cases were dismissed on the grounds of the finding that vaccines do not cause autism. So that, again, was a big change. In part, you saw a lot of cases lose in those years because of the results of because a lot of those were about autism. In 2017, the table of injuries that addresses which injuries are presumed to be caused by vaccines was revised and updated. Shoulder injury related to vaccine administration was added as a potential injury to all vaccine. So was fainting, syncope. And other major changes were made then. Until 2017, the program hasn't been changed for over 10 years. It was out of date. So that was a big deal. And finally, in 2015, I should have put it earlier because it's the 21st Century Cures Act, which confused me, but it actually was passed in 2015. The Cures Act added pregnancy vaccines to the table. So now people who got a vaccine in pregnancy could bring claims from them or for harm to the fetus, which wasn't allowed before that. Let's talk a little bit about the technical aspects of the program. So the program is under the heading of the United States Courts of Federal Claims. What is that? That's a court created by Congress, but it's not a regular federal court. It's a special court that's aimed at claims for money against the federal government. It was renamed in 1992. It's a very old court. It had 16 active judges, and they're nominated for 15 years. So while they're politically nominated and do not serve for life like federal judges do, they serve for a very long time. They're pretty independent from the rest of the executive. The president gets to appoint who is the chief justice. Under the Court of Federal Claims, the ones that actually hear cases for vaccine courts are the special masters. Who are the special masters? The special masters are administrators, bureaucrats that are appointed by judges of the Court of Federal Claims. They're appointed for 4 years, but they usually stay for a long time. The appointments are usually renewed kind of automatically. Notice that they're not appointed by the president. They're isolated somewhat from the executive. They are the ones that actually hear the cases, and they make the findings about entitlement to damages, how much damages, and how much to award attorneys or fees or costs. Because as I'll repeat later, one of the features of the program is that attorneys in the program get their costs and get their fees and expert costs awarded. For those that are familiar with other administrative law judges, such as Social Security, they have similar authority to those judges. It's not unusual in the administrative state, but they are bureaucrats, not official judges, even though their role is very like a judge in a trial court. The special master can, but doesn't have to, order discovery, manage when to have a hearing, whether to have a hearing, and how to decide on motions. And the special master's job is inquisitorial. What does that mean? In our courts, judges are supposed to lean back and let the parties argue it out, except when they're asked to rule on motions. We are an adversarial system, and the parties have the main role. In vaccine court, because it's more of an agency than a court, the special masters are allowed to take a more active role. For example, they're allowed to themselves interrogate experts. They're allowed to ask for more evidence and more experts. They're allowed to take a more active part in getting to the truth. Since they tend to stay, they develop quite a bit of expertise over time. So if you're looking for more expert examination of cases, that's an advantage. If you think you'll be better able to pass a weak claim off over a jury that doesn't understand the issues as much, that's a disadvantage. Where does the money from the program come from? It comes from an excise tax on every vaccine dose. The manufacturers are the one responsible for paying it. However, as they do when they, for example, if manufacturers have to buy a liability insurance policy, they would add money to the cost of the program, roll the price on customers. Here too, manufacturers add this price to what they charge customers for vaccines. The current tax is 0.75% per dose. That means, for example, that if you're giving someone MMR, that counts as 3 doses of vaccine, and the cost would be 0.75 times 3, which I should know, but don't want to embarrass myself by getting my math wrong in a live webinar. Right now, the program has a really big surplus. It has over $4 billion of money because compensations compared to vaccine doses are limited. There just aren't that many cases. So the numbers here are a little misleading in the sense that the first number is from a different time than the others, and that's because of the way the report for the vaccine is done. If you want to double check this, just Google vaccine injury compensation data, and it should link you to a government site, HRSA, which has the most recent compensation data report. The most recent one is from September, and that's the one I used. It has a counting of vaccine doses, but that's a little more delayed than compensation. Compensations they control, they can tell you how many they have. Doses they have to rely on others to count. So between 2000 and 2013, the program had over 5 billion this program. We have given over 5 billion vaccine doses in the United States, and the program has it broken down by vaccine. And between its creation, so it's a different time frame, between 1989, when it started operating, and September 2025, the program compensated 12,000 people out of 25,000 claims that it addressed. It gave plaintiff over $4 billion, which I realize sounds a lot, but remember that this is over 12,000 people, and that one injury that leads to permanent paralysis, for example, is going to cost millions because you have to cover costs of a disability over a lifetime. It also covers attorney fees. As you can see, it paid over 380 million in attorney fees, and it pays those attorney fees even if you lose. It has a number for dismissed cases. So over $135 million out of that amount were paid for cases that lost, and I'll get back to that. How does it work? So as you can see, I'm taking this from another site, My Vaccine Lawyer site, but it's actually a really good depiction. So you file a petition with the U.S. Court of Federal Claims. It's examined both by a unit in the Department of Health and Human Services and by people by a unit at the Department of Justice. The people at HHS may offer a concession, may say, well, this fills the criteria, let's just compensate this. And they do it in consultation with the unit in the Department of Justice that would have to defend it if it went to the court. They may, as it says, begin settlement discussion. If HHS decides not to compensate, the case goes to a hearing before a special master. In that case, the representation is by a unit in the Department of Justice, not by HHS, although HHS stays involved. And each party needs to usually brings medical experts. The party that's bringing the case has to show causation to the standard. So they have to bring in medical records and other evidence. They have to show that the person got a vaccine. Yes, sometimes cases are filed and it turns out that there's no evidence the person got the vaccine. And they have to show from the medical records that the alleged injury happened and show causation. We'll talk about causation in a few minutes. If the petitioner wins, the program pays compensation. There are several layers of appeals here. We'll talk about going to state court in a moment, but let's say you don't want to go to state court, but you're unhappy with the result in the program. You can appeal it to the Court of Federal Claims, to those 16 judges appointed for 15 years. If you don't like what you got there, and the government can also appeal, by the way, if you don't like what you got there, you can then appeal to the federal circuit courts that's relevant to your district. And it can go all the way to the Supreme Court. The Supreme Court has the right to take or not take cases. It's for everything else, it takes less than 1% of all the cases given to it. It rarely takes these cases, but it sometimes has addressed cases from vaccine court. So there's an appeal within the federal courts. Some limits on this. It has to be a covered vaccine, so it has to be on the list I showed you. That means that it has to be recommended by the Advisory Committee of Immunization Practices. If the Advisory Commission unrecommends a vaccine completely for children or pregnancy, it can be taken off the program. Then the secretary has to go through a rulemaking to add it to the table of injuries and add conditions that are presumed caused by this vaccine. It also has to be in a certain time. The statute of limitation from the program is 36 months. For death, it's shorter, 26 or 48 months. It also has to be for a severe condition for 6 months. So if you have a short-term thing, unless you were hospitalized or died, you can't bring a case. But if you had a severe condition for 6 months, or if you were hospitalized even for a short time, or if there's a death, you can bring the case. If you bring the case, you need to show that the vaccine caused your harm, you need to show what your damages are, and you need to show which lawyer fees should be shown. Causation is where a lot of the debates happen. So let's talk about that a little more. How do you show causation? There's two ways you can show causation in vaccine court. One is by showing that the vaccine caused an injury on the table of injuries within the time frame. This is an example of a snapshot of the table. The table is much longer than this. As you can see, it names a vaccine, it names certain conditions, and it names a time. If you had anaphylaxis within 4 hours of a tetanus-containing vaccine, we are presuming that the vaccine caused your allergic reaction, and you should be compensated pretty automatically, unless the government can show there was another cause. Off table, you have to show causation to a standard that's like civil courts, but a little less demanding. That's the Alphen standard. This is a quote from the case. You don't actually have to read it. But there's 3 parts to this. You need to show a medical theory supported by a credible expert that is drawing on the literature. You need to show a logical sequence of cause and effect between the vaccine and the harm. And you need to show the timing. The timing has to be reasonable. In some ways, this is easier than in civil courts, even though it's not, you still have to show causation, in that in civil courts, you would have to show that there's actually scientific evidence supporting your claim. Here, if the science isn't there yet, a plausible theory with an expert would still be enough. However, if there is science and it's against you, you might still lose. So it's to some degree less demanding than a civil courts. Though again, you still have to show causation. In terms of damages, you can get your medical expenses, you can get lost wages, but only for the person injured. Pain and suffering and death are capped, and the cap were created in the 1980s and haven't been raised then, which is one of the drawbacks of the program, really. Caps should either be indexed or raised. Sometimes in today's term, this is a very low cap. And reasonable attorney fee, even if you lose. And I'll go back to that in the next slide. Yes. You can't get punitive damages, which you could if you could show, say, fraud or very bad negligence in civil courts, but only then. And the only expenses for someone else besides the injured person would be for parents of an injured infant. Lawyers' fees and cost. Again, one of the advantages of the program is that it covers reasonable fees and costs, even if the person lost, as long as it was reasonable to bring the case. There's no contingency fee. That's a disadvantage to the lawyers, which in other courts would get 30 to 50% of the damages, but it's an advantage to the petitioner, which gets the whole award. And it's, for the lawyer's point of view, it's offset by knowing that they'll be paid even for losing cases, as long as it's reasonable, which of course raises a question, what's unreasonable here? When don't you get paid? So there's two cases that have been refused by the program so far. If you bring a case after the statute of limitation is passed, the program won't pay the lawyer, saying you should have known that this is past 3 years and you brought it in bad faith. And the program has recently stated that it's going to no longer compensate lawyer fees for cases on autism unless there's something really new, because it has relitigated that issue again and again. Can you go to court after that? So the short answer is yes. You can go to state court if the program has delayed more than 240 days. So someone files a case, there's no decision within 240 days, and petitioners have several ways to delay the case if they really want to. And we see that sometimes. You can pull the case out and go to a state court. Or if there's a decision either for you or against you, you can say, I don't want this amount of compensation. I think I can do better in state court, or I lost, I'm now going to state court, and you can go to state court. There's a limit on what you can go to state court for, which is in 2011, the Supreme Court decided that you cannot bring a case for design defect. That's actually a pretty big limit, because a lot of vaccine claims will try to claim the design of the vaccine was defected, the risks are bigger than the benefits. But it still leaves open to people going to state courts claims of the vaccine was badly manufactured, there wasn't enough warning, there was fraud, and or there was negligence. If you show negligence, you're good. You can go to state courts. On warning, I will add that there's a limit in the statute that says manufacturers have to warn the doctor, not the patients. That's called the learned intermediary doctrine. When people say you can't go to state court, that's simply untrue or simplistic, because you can go to state court for many types of claim. For example, there's now litigation against Merck over its Gardasil vaccine, over 200 cases, some of which were filed in VICP and then pulled out and refiled in state court after the time expired. Some of them didn't have any medical records submitted. In other words, there wasn't even an attempt to win in VICP. Some of them lost in VICP. But there are cases in state court right now against Merck over Gardasil. About 200 were consolidated in a multi-district litigation into one court, and those were dismissed by the judge. Plaintiffs are now appealing, but I think they're going to have a hard time because the judge decision was very much based on the facts, and that's hard to challenge. Numbers. Out of 28,673 cases filed since the program, by June 25, about 25,000 were decided, 12,000 were compensated, 13,000 were dismissed. You look at this and you say, well, over half were dismissed. Keep in mind two things. First, in product liability claims, we don't have a lot of numbers, but one source from 2005 found that wins are about 33% of product liability claims, which is the closest parallel. So a lot more of those cases would lose in the civil courts. And second, look at the numbers more closely. If you look from 2014 and on, most cases are compensated. Before that, a lot more cases lose. And if you look at the timing, a lot of those cases lost in 2011, 2012, after the autism decisions that we talked about. So at least to some degree, these numbers are affected by the fact that so many autism cases lost. So here's a question for you. Which of these is a real change in VICP since it started? Since I don't know why it isn't working, and I apologize to members, but if after a few minutes you can tell me what's going on in the chat, I'll address it then. Please answer in the chat if we can't answer here.
Yeah, so I am seeing, at least so far, lots of A's, 1C, 1B, but consistently lots of A's so far, Dr. Rice.
Very good. The people answering A are correct. Starting from the bottom, the maximum compensation for death has not increased, and I think that's one of the problems. We do need to increase that. That's D. Going to C, VICP still covers lawyers' fees. B, the rate of compensated cases actually rose in the past decade rather than dropped. So the correct answer is A. At the beginning, most compensations were for children. Today, it's mostly for adults. Hup. No program is perfect, and this one certainly isn't. There are some real problems with VICP. One is it only has 8 special masters. That's in the statute. That's not enough for the cases in the program, but to change it, you would need litigation. So we need to change the law to increase the number of special masters if we want cases to move more forward, and if we want cases to be handled more, or if we want to add COVID vaccines, we definitely need more special masters because that'll be a larger number of cases. The caps, as I already mentioned, were set in the 1980s, not raised since then. They really should be raised. The next one is a little more controversial. The statute of limitation in the program, I think, is too short. 2 to 3 years, which is this program's statute of limitation, is typical for a tort case. But for most tort cases in the States, it's put on hold for children. That's not true in this program, which means that parents who realize there's a problem 2 or 3 years too late won't be able to sue. And that's essentially sacrificing the interest of the child who doesn't have a choice here. So I think the statute of limitation should be raised or relaxed for children. The program has suffered from delays. There's a number of reasons there. Part are just objective reasons, such as not enough special masters or petitioners delaying, maybe if they want to raise 240 days or they need more evidence. Or again, the special masters have been very lenient with people who need to bring more evidence. But they've worked on closing those gaps and improved some. It's still could be always, you can always say about programming, could be faster. They improve things, there's still more work to do. And opponents point out that the program is too adversarial. One example I heard from a researcher is that sometimes the government argues with petitioners which type of diapers they should use for a child that's going to be in diapers for most of their life. So it probably is too adversarial. I will point out that in the United States, other no-fault program has run into adversarialism as well. So it might be a cultural problem, but if we can reduce it, better. Now I'm going to switch gear a little and talk about the countermeasure injury compensation program. I'm talking about it because that's the program COVID-19 vaccines are currently under, but I'll keep it short because it's a very different kind of program, and I hope that we'll reform this soon, but can't count on it. So this program was created for emergency times. It was created under the Public Readiness and Emergency Preparedness Act of 2005, which aimed to give access to product during an emergency. It allowed the Secretary of Health and Human Service to create declarations that protect manufacturers and administrators of countermeasures from liability. The goal is to encourage manufacturers to make those products and to make sure that administrators actually give them, because if there's liability, we might not have people using them in an emergency. There's a PrEP Act, there's multiple PrEP declarations for COVID-19, and they cover tests, vaccines, and medication, any COVID-19 products until 2029. I will mention the Secretary can overturn them at will and hasn't done it yet. So this might change, but when they're in place, manufacturers and administrators of products are immune from liability, with one exception that I'll mention in a moment. And they need to go to this counter injury compensation program. What does this program do? You have to request benefits. It's reviewed by the staff. This is not an adjudicatory process. There's no special master. And if they think you deserve it, you apply for how much compensation you get. You can appeal it to an official in HRSA, and the associate administrator of the healthcare system bureau of HRSA gets to make the final decision whether you get it or not. There's no real hearing. It's not the same kind of trial-like process as in VICP. To be compensated by CICP, you need to show that the covered injury is from a covered countermeasure, and you need to show it with compelling, reliable, valid medical and scientific evidence that it's either on the table of CICP or is a direct result of a covered countermeasure. This is a really high standard. If the standard for VICP is lower than the court, here you really need a lot of medical and scientific evidence. It's doubly problematic because these are emergency products. If they were created fast, there just isn't time for them to be that compelling medical and scientific evidence. So this is a really, really hard thing, especially since the statute of limitation here is 1 year from when you got the product, from when you had the symptoms. So you have very short time to get a very high level of evidence. And as I mentioned, this really bars you from getting to state court unless you can show willful misconduct, which means intentional injury and is a really high bar. So CICP is not a great program. My personal opinion is that we're shortchanging people who think they were injured by COVID vaccine or were injured by COVID vaccine. Can't know without looking at the cases. It's a really hard standard to meet. There's no real legal alternative. There's no judicial review. You can't take this to the federal courts. I really think we need to find an alternative for COVID-19 vaccine. The easiest alternative is to move them to VICP. But for that, two things need to happen. A, Congress needs to pass an excise tax on the vaccine because otherwise statutory, you can't add a vaccine to the vaccine injury compensation program. And B, you need to add special masters because otherwise the program will grind to a halt. There's not enough people to address those cases if they come in. So there's one last question here, which is about the differences between VICP and CICP. Please write your answer in the chat. And Kylie, I'm going to ask you again to serve as my person who tells me what's going on.
Yes, absolutely. Okay, so as they start coming in here, I see 3 that have answered B. I have C, another B, 1A, 2 A's, but lots of B's so far.
So this is obviously a confusing question, and I obviously rushed through it too much because the correct answer here is D. Everything else here is actually different. The standard for showing causation is much easier for VICP than CICP. The bar for CICP is really high, compelling medical and scientific evidence. The statute of limitation is shorter for CICP than VICP. It's 1 year compared to 2 to 3 years. It's a lot harder to take a case to civil courts if you're under CICP than VICP. But in both cases, you will need to show causation to some degree. So that's about the difference. I have about 5 minutes and I want to tell you what we're seeing that might change. So there's 2 sources of changes. First, Representative Paul Gosar has twice submitted a bill to change the vaccine injury compensation program, one in the 2023 to 2024 Congress, and now again. I haven't seen it move, but it's in the works, and he has the support of the Freedom Caucus in Congress. This bill would remove manufacturer's immunity completely and remove the statute of limitation. So people who think that in 2000 a vaccine called the child's autism will now be able to take the manufacturer of that vaccine to court. This will remove any liability protection from the manufacturers and can bring us back to where we were in the 1980s, where manufacturers are leaving the market. In addition, Secretary Kennedy has made it clear that he's looking to reform VICP. The problem is that we don't quite know what specifically he wants to do because he didn't give the details. He mentioned that he wants to allow more discovery. Right now, discovery is in the discretion of special masters. Secretary Kennedy said that he wants more of it. He also mentions he wants less delays. And I will point out that there's a little bit of tension here. More discovery delays cases, so it will mean less cases. He said that the system is broken, but again, that doesn't tell us what exactly he wants to do. So the biggest problem we have with Senate Secretary Kennedy plan is that we don't quite know what he wants to do. Secretary Kennedy has also dismissed the Advisory Committee of Immunization Practices and put in place other members. That's relevant because if ACIP removes a vaccine from recommendation to children or in pregnancy, it can be taken off the program and sent to the regular courts. So that could be. It was rumored that he will add autism as a table injury, but it's not clear why. That will require rulemaking. So we should have noticed in advance an opportunity to submit comments, but that could increase pressure on the program in the sense that it will make it easier to be compensated for people who are claiming what vaccines cause their child's autism. And further, when you change the table, you open the claims for people 8 years past. So you relax the statute of limitation. So people who think their child's autism was caused by vaccine in the last 8 years can now bring claims. And there's Secretary Kennedy mentioned that he thinks we should add COVID-19 vaccines to the table, to the program, which again, I agree, but he can't do it by himself. That's something he needs Congress to do. And I will mention that there was a lawsuit brought by a lawyer that works for Children Health Defense, the organization Secretary Kennedy was part of before he became secretary, saying that you can add COVID-19 vaccine to the VICP now, but that was dismissed since the court agreed that you have to have an excise tax. I'm going to stop now to leave, hopefully, enough time for questions. Thank you. Feel free to email me later if there's something you think of later and we haven't gotten to. And I will let Kylie and the rest of the wonderful team take control now.
Wonderful. Okay. Thank you, Dr. Rice. That was incredible. I know I learned a lot, and I'm sure there's lots for us here to digest and maybe even go back and watch once the recording's available. We're going to get to questions here in just a moment. Please use the Q&A function on your Zoom toolbar. We'll get to those in just a second. But for those claiming CME, please follow the link on the screen or in the chat to take a post-test. You have to do that to get your CME credit. If you're doing continuing pharmacy education credit, please follow the instructions on the screen. A recording of the webinar along with the presentation slides will be available on our website and YouTube page. And we'll have CME credit for those as well. You can only take the credit once. More details on our next webinar will be available in our email. Okay, first question for you, Dr. Rice. How can providers communicate with patients about the NVICP without undermining confidence in vaccines?
Can you repeat that? Sorry, I didn't hear the last part.
Yeah, so how can providers communicate with patients about the NVICP without undermining confidence in vaccine?
Good. So at the end of, so providers are required to give patients a vaccine information statement before giving them vaccines. At the end of it is a small section of VICP. I don't know if it's a practice for providers to go over that, but one way to approach it easily is to spend a couple of minutes going over the vaccine information statement, pointing, here's where you see why you need the vaccine, here's a description of the disease, here's what you see are the risks of the vaccines, and they're pretty small, and here's what you can do if anything goes wrong, which is unlikely. You can report it here. There's also information about VERS, and here there's a no-fault compensation program that's easier than the court, that you can go for compensation if anything goes wrong. So I think one way to do it is kind of made it part of going over the vaccine information statement as part of the discussion rather than on its own. Of course, if someone calls you after the fact and is concerned about the vaccine injury, I mean, at that point, mentioning the program won't undermine confidence. It might help them to know that there is such a system.
Awesome. Thank you so much for that answer. I'm going to take over the questions here for just a moment. One of the other questions we had come in was, is there a process or compensation for injuries from non-routine vaccines, such as travel vaccines, that aren't in the table, the HRSA table?
That's a great question. So the answer is you'd have to go through the regular courts. And that's true, for example, also for vaccines that are specific to adults, such as shingles vaccine and the PCV. I think the one for adults is 20 or 23. For vaccines that are not recommended to children or in pregnancy, your only recourse is the civil courts.
Okay. I guess kind of leading on with that, is there any process, do you know of, to have a program for specific adult vaccines?
So we would need to change the statute, and it's totally feasible. I mean, the statute can be reopened and said any vaccine rather than just covered vaccine that are in the table. You could do that. You just would have to legislate. You'd have to go to Congress and go through the very hard legislative process at the federal level.
Thank you so much. I think our next question, I'm just going to kind of bring on some of the current events, I guess. We've had some questions about it in the chat. So
Please.
this morning there's been a lot of news about the changes to the CDC
Yes.
webpage about vaccines and autism. So you mentioned the omnibus autism proceeding. Can you maybe comment on what could happen if autism was added to the injury table? And if the
Yes.
secretary has authority to add that, I guess you did touch on if the secretary has authority, but could you maybe expand on that?
So let me start from the process for doing that, and then we'll get to that. The secretary has authority to change the table, but the process to do that is spelled out in the statute, and it's pretty elaborate. You have to have an opportunity for comment that lasts about 180 days. That's in the statute. That's not made up. So you have to publish notice in the Federal Register, open it for comments, and write a response to the comments with the final decision. And it can be litigated. This is something that could be taken to court, although you need someone who has a personal stake, and that's not trivial. If the secretary adds autism, so it partly depends how you do it. So if you do it by one of the things discussed is broadening the definition of encephalopathy, capturing a lot of things in the definition of brain disorder, which is right now defined very narrowly. If you do that, then so what happened will be that we'll see cases of a lot of people who think that their children's brains were harmed by vaccines. So one of the reasons I'm a little hesitant to give you a very definite answer is it depends on the actions of a lot of people in between. The changing the table will open the floor for claims from people who are barred by the statute of limitation, but only for claims going back 8 years. So the people who brought the original claims in the 2000s won't be able to bring those claims. So the real question is how many people in the last 8 years how many people think that vaccines cause their child autism in the last 8 years and will be willing to bring those claims? There'll be anti-vaccine groups will be trying to encourage people to do that, but I don't know if today there's that many because today there's a smaller percentage of autism parents who blame vaccine than in the past. If there are a lot of claims, there are a number of concerns. One is bring the program to a halt because there's so many claims that 8 special masters can't get to them. So creating a backlog and preventing things from moving. The other is that will exhaust the fund. We mentioned that right now there's a surplus of 4 billion in the fund. If there's a lot more claims, we might run out of this. And a child with severe autism, a child who needs extensive treatment, can cost quite a bit to the program. So we'll exhaust those funds. Those funds are there for people who are injured by vaccines, but if you add in people whose injuries are probably not from vaccines, you can exhaust that money and leave nothing for people who are injured by vaccines. Congress will then have to decide if it's going to add money, increase the excise tax, or what to do. And I don't know what it'll do in that situation. So those are the two main risks, creating a backlog and bringing the program to a halt, or exhausting the funds. Remember that Congress can always step in and do a number of things: overturn the program, add money, narrow the requirements. Congress can say in the statute vaccines, autism is not if a child has autism, the child will not be compensated by the program. So there's things that can be done, but they will need political will. And the first thing is that the process for adding autism to the table is not fast or easy.
Awesome. Thank you. I think that was a really great explanation for kind of a question on a lot of people's minds, as we can see from the chat. I'm going to ask another question here from our chat. So if hepatitis B vaccine was removed from the ACIP recommended for infants, would it then be removed from the VICP list?
Good. So you'd have to remove the vaccine completely for children or in pregnancy. Hepatitis B vaccine is currently recommended at birth to, I think there are 5 or 6 doses before a child is 2, but you guys are the doctors and pharmacists that know more than I do. So if I got it wrong, please correct me. So it has to be removed completely for children. That wasn't on the agenda of ACIP last time. If they do it, if they say children under 18, it has to be under 18. If they say you get the vaccine at 12, it's still within the program. If they completely remove it, the secretary can then open rulemaking and remove it from the program as well. But they'd have to, if they're just discussing removing the birth dose, they're not there yet.
Perfect. Thank you so much. I think I'm going to narrow us to 2 more questions left. So this first one, I think you briefly touched on it, but we had another question come in. So what would happen if vaccine manufacturers were to back out of vaccine production, essentially?
We'd have a problem. If there aren't vaccines in the market, we don't have them. We may have to, people who can travel may have to engage in vaccine tourism, and a lot of people might run out of access. So one risk, and it's a very realistic risk right now, is that manufacturer will be uninterested in dealing with changes to the system and will step out of production of vaccines. So that's a very realistic risk. Another risk that you haven't asked me about, but I'll mention anyway, is reducing access. If ACIP changes the recommendation, the first thing that will be impacted is not VICP, but the Vaccine for Children program, which depends on ACIP recommendation. Remember that about 50% of the children in the United States are eligible for Vaccine for Children program vaccines. So if ACIP, for example, remove hepatitis B birth dose, the first hit will be that parents who are not hepatitis B positive that want the birth dose will not be able to have it covered through the program and may not have access.
Perfect. Thank you. I think I'm just going to finish with this one question here. So you had mentioned that ideally this program increases vaccine confidence, but it has been used as a talking point by anti-vaccine activists as well. Do you have any ideas for talking points or framing for the program that emphasizes the benefits to the vaccine consumer?
Yes, I have the discussion routinely because you're exactly right that anti-vaccine groups have used the program. For example, you sometimes hear over $4 billion have been paid for people injured by vaccine. And I think that the only way to handle it is to use it as a conversation starter. A couple of talking points, because that's what you asked about. One, 4 billion over 30 years with millions of vaccine doses given each year, even without the math that shows that it comes down to one compensation out of a million or 2 compensations out of a million, is a very low amount. One serious injury costs millions of dollars. So put in the right context, this is not a large amount. 2, I think it's worth pointing out that in recent years, most of the compensations are for adults who have shoulder injury for bad administration. The best talking points are the facts, and that's one of the facts. 3, I like to remind people that we have an easier system to compensate people harmed by vaccine because we care and we want to make sure there is compensation available. We don't have anything to compensate people who were harmed by non-vaccination. The parents of the 2 children who died from measles this year aren't going to get any compensation from anyone because there isn't anything there to compensate when a child is hurt by a preventable disease because the parents didn't vaccinate. And four, I would go back to this one. This system was partly created to protect manufacturers, but to a large part was created to make it easier for claimants. And it's better for claimants to have this easier option than to have to go through a court system, which is not easy at all. I hope that helps.
That's wonderful. Thank you so much. So I guess we'll just wrap up here. I want to thank everyone for joining us, and thank you, Dr. Reiss, so much for this awesome presentation. We really appreciate it. And I guess we hope to see everyone at our next webinar.
Thank you.